intelligence to determine whether they're just a small actor and really couldn't make a difference, or if they're like Amazon was.
Excuse me, Counselor, you keep asking us to look at the underlying reasons. Does that mean you don't think the language itself supports your position?
No, I do. I absolutely feel as though under the facts of this case that the otherwise participate in the facts in this case do support our position.
Okay, well, I'm trying to get there based on the statutory language, not based on your policy reasons, because that would seem to always counsel for liability no matter the case. So I think we have to look at what language the legislature chose to use and what that means. So under your reading, they're a supplier. Why? Because they made it available on the internet?
Well, Your Honor, they did much more than that. What they did was they listed the product. They made a decision to list the product. They selected the product.
Okay, but help me with each one of those. Which one of those makes them a supplier? For example, is eBay a supplier?
I'm sorry?
Would eBay be a supplier?
eBay has a different agreement in terms of eBay does not have the control of the sales transaction or the listing that Amazon has. So it's a different contract that eBay has. Amazon totally controls the transaction. They control the listing based on what they call the BSA, which is the Business Solutions Agreement, which is the agreement that Amazon has with their selling partners, and it dictates every transaction that occurs on Amazon.com. It is different than an eBay agreement.
Counsel, excuse me, how do you address the fact that Amazon never had that control of the product?
Okay, in terms of that, you don't have to have possession to participate in placing it into the stream of commerce. Actually, I would turn the court's attention to Damon Jones, who was identified as the witness for Amazon, the 30B5 witness, and that's in the record at 326. And on page 109, he specifically was asked, why does Amazon, under the agreement, why are they entitled to collect all of the sales proceeds? And he said, because one of the reasons was because it allows Amazon to control the transaction and it eases the flow of the product. So in terms of that testimony alone shows they control the entire transaction and they ease the flow of the product. They have total control.
Counsel, what does that mean? Counsel, what does that mean, ease the flow of the product?
Well, in terms of that testimony, it means they control when that product is shipped. Their third-party supplier, or Tencoris in this case, they are not involved in the sales transaction at all. They basically, all they do is
they get the word from Amazon that a consumer has enlisted or has paid for this product. Go ahead and ship it, and here's where you ship it to, and here's the amount you ship, etc.
Exactly, and based on Damon Jones' testimony, Tencoris is not allowed to do that until Amazon has completed the purchase, has completed the transaction. Then they send them an email and with the information that you just explained, along with a shipping label. All they have to do is push the button and print out the shipping label. They're not allowed to have any other contact with the purchaser, and in this case with Kelsey Kidd.
Well, it works to the advantage of the Tencoris to make sure, the Amazon is making sure that it's a complete transaction. You're paying with a credit card or some other method, and that's valid. And then I'm presuming that's what needs to take place. And then Amazon will pull the trigger and say that Tencoris can ship it. Is that correct?
Absolutely.
So they're a clearinghouse for the financial transaction.
Well, not just the financial transaction. They're more like a sales agent, because they're the only ones that communicate with the purchaser. As a matter of fact, they're not even allowed. The Tencoris is not allowed to even contact or have any information regarding Kelsey Kidd. So in terms of that, they're more like a sales agent.
Well, why would they need to have any contact with the consumer here?
Well, because in terms of it, there's a problem with the product. Let's say, like in this case, You know, this was on Amazon.com for over almost 4 years. And there were a lot of safety concerns that Amazon was aware of. Tincourse was not aware of those. There is no way for the consumer to notify the supplier, in this case, that there are problems, there's safety concerns with the product. So
Well, when you say supplier, do you mean Tincourse?
I mean Tincourse, yes. They're supplier, or they're the selling partner is the word that Amazon used during the congressional hearing to explain the relationship.
When you say that Tincourse is not allowed to have any information on the consumer, how do they get the product to the address?
Correct. They're not allowed to have email. They're not allowed to contact them. Very limited information are they given.
So they are given some information now. They have to know where to send the product.
Just the shipping information once the transaction has been completed. And so they won't know where to ship the product until Amazon tells them. So Amazon is participating in the sale.
If there's a problem with the product, how does the consumer relay that product? Let's say the container was open when the consumer received it.
They have to go through Amazon. They're not allowed to have any contact with Tincourse or with the supplier.
Then Amazon contacts the supplier about the problem.
I would assume, yes.
Counsel, is that standard universal policy of Amazon that the folks like Tincourse or businesses like Tincourse cannot have any contact with the consumer?
Yes, Your Honor, it is right in their BSA. If there's any contact, it would have to go through Amazon. So if there's a problem with the product, Amazon actually provides an A to Z guarantee. In other words, they guarantee that it's what you thought you were ordering. They guarantee that you can send it back to Amazon. You don't take it and send it back to Tincourse or their selling partner. It's through Amazon and it's to Amazon. Amazon controls all of that information. And in this case, Amazon, before they selected the product in terms of participation in placing the stream of commerce, they were aware that just a small amount of this product could kill or could be lethal, because they already have it set up, algorithms that when there are key safety words such as die, death, they are alerted. Their safety team is, and what they then do is they investigate whether it's safe to continue selling on Amazon.com, because we all trust that what they have is safe. And I'm concerned about running out with the time that I have for rebuttal, but Amazon's safety team is not allowed to investigate third-party products based on their policy. They only investigate the ones in which Amazon list themselves as the seller.
So they don't put this product through their associating with the algorithm that death, die, dangerous or whatever.
No, they absolutely do, but the policy states do not investigate. File the concern in a shared mailbox and move on. The only thing they investigate are theirs. They don't investigate safety concerns on the third-party products. If they're subject to strict products liability, it would be an incentive for them to make sure all the products are safe, not just ones they think that they would be liable for. And I would like to reserve my remaining 2.5 minutes for rebuttal, if I could, Your Honor.
All right. Mr. Murphy.
May it please the court, Brendan Murphy for Amazon.com. I would like to start with the statutory question that Justices French and DeWine ask about before I proceed to address some of the factual inaccuracies, which I'll address if I have a little bit of time. Product liability in Ohio is a matter of statute and only a matter of statute. In 1988, the General Assembly took product liability out of the common law realm and carefully balanced the interests and defined the entities liable and the conditions under which they would be liable. And it provided a definition of supplier. That is the legal issue upon which this appeal turns, is whether Amazon qualifies under the statutory definition of supplier, and it does not. The statutory definition begins with 7 action words: sells, distributes, leases, blends, packages, and so forth. And there's really no dispute, and there never really has been a dispute, that Amazon did not do any of those things. Amazon never touched the product, didn't set the price, didn't offer it for sale. Those were all done by Tencoris. I don't think any of that is disputed. So this case turns on whether there is room within the otherwise participates in the placing in the stream of commerce language for these broad concepts and undefined concepts of promotion, of being somehow indispensable to a transaction, or importing.
Counsel, is that where the line is, the physical control? If Amazon had taken this product into one of its storage facilities before it was distributed to the consumer, would that have made a difference in whether they had crossed the line?
No, and that is the precise issue addressed by the Fourth Circuit in the Erie case involving the Fulfillment by Amazon program. Fulfillment by Amazon is a logistics service where certain sellers choose to send their inventories to Amazon fulfillment center for storage in the seller's inventory. The seller keeps title. And then when a customer like Kelsey Kidd places an order, the fulfillment center hands that from the seller's inventory to a shipping carrier like UPS. So if possession were the key, then that would be an incredibly broad proposition. FedEx, UPS, DoorDash, entities like that who do have physical possession of a good would then be liable. So it has to be something much more significant than possession. So possession.
So if it's not possession, you listed these 7 items, and I think your argument is that the otherwise participates has to be like those 7 items. What do those 7 items have in common? What is the category we're looking at?
So the commonality among those 7 action words is some sort of ownership or control of the product. You don't necessarily have to own a product to label it or whatnot, but you have to have some sort of control over it.
The fulfillment center would control the product.
I'm sorry?
The fulfillment center would control the product.
Well, only in the sense of having physical possession. It doesn't do any testing or anything like that. So it can't be just physical possession, because that's simply an overbroad conception that would sweep in everybody. And I want to make clear that this is not an FBA case. This is a case where the merchant, Tencoris, shipped it directly to Kelsey Kidd after she placed the order on with Tencoris on Amazon.com. So the commonality is ownership or control of some kind, plus some sort of hands-on action with the product. Deciding what the label is, putting it on there, deciding what the package is going to be, putting it on there. And this court gave a couple of examples in the Anderson case in 1991. That was the overhead lift case, where it was talking about what it means to place something in the stream of commerce. Now, that's a pre-OPLA case, even though it's after OPLA was enacted. The accident was pre-OPLA. But the court cited 3 cases: Perfection Paint from Indiana, Delaney from the Second Circuit, and the Cessna case, I think, from Alabama, that gave 4 examples of what placing a product in the stream of commerce is. One would be sale. Before
you get there, Mr. Murphy, I guess what will be helpful is trying to understand this otherwise places in interstate commerce. If it doesn't mean this, what does it mean? Give me some examples of what that language would cover.
Oh, certainly. And I'll give the examples from Anderson. Providing a demonstration unit, providing a free sample. Perfection Paint, for example, discussed in Anderson as the lead example, involved providing a liqueur to remove some paint from the floor that ended up causing a death. So those examples all involve the entity selecting a product and providing the product, not just physical possession, because any number of entities may have physical possession of a product, but not any kind of meaningful control. So the 4 examples from the 3 cases discussed in Anderson are sale, lease, demonstration unit, and free sample. There, you could conceive of other cases like Torres versus Goodyear or Castle versus Remington Arms. Those were Arizona and California cases involving trademark licensors who essentially design the product and license out the design, but wouldn't necessarily fall within one of these 4 things, but they, for all practical purposes, are designing and making the product just sort of by virtue of their corporate relationships, sourcing out to other entities. So it's not by any means.
Excuse me, counsel. What's your response to opposing counsel's argument that Amazon's algorithm selected the product?
There is no record support for that claim. I would direct the court's attention to record 189 at pages 56 to 59. That is the Kelsey Kidd testimony where she talks about how she came to select the product. She went onto Amazon.com, she typed in pre-workout, and a number of products were listed. She then clicked on one of those, and only after she went into that second level of selection did she see or testify that she saw the hard rhino pure caffeine powder as listed as one of the things she might want to buy.
Who orchestrated that? Who orchestrated from hopping from one product that originally shows up, you click on that, and then it goes to the other? Is that Amazon?
No, that was Kelsey Kidd. She is the one who clicked on it, and she was very clear that she actually said she chose.
Okay, wait a second. She puts in pre-workout. This product, a list of products come up. She clicks on one. That directs her to another product, a similar product, right?
No, that takes her to the product detail page for the product that she had selected. And then once you're on the product detail page, there are other listings. There might be sponsored products. There might be products you might like.
Right.
Products other
Who
people
creates that? Who creates that page?
The algorithms that do the search results, that is Amazon. I'm not
so
actually
Amazon promotes or brings to the attention of the consumer at various stages in the search products based on algorithms, and you can go down, a rabbit warren trying to, on your way to selecting a product. I think we've all done that, correct?
Certainly, and this is search functionality that pretty much any effective website does provide. For example, when you go into DoorDash.
All right, we're not talking exclusivity here on this, process. Does Tancoris sell their product through any other format?
Yes, and that's very important in responding to the claim that this was somehow indispensable. Ken Olcher testified, this is at our record 282, pages 12 and I believe 74, 12 and 72. He testified that Hard Rhino Pure Caffeine Powder was sold on eBay and on Tancoris' own website. So Amazon was absolutely not indispensable or crucial or somehow responsible for introducing this product.
Do you know the percentage of transactions for this product, the bulk or the majority through Amazon or through Tancoris' own webpage or eBay?
I don't have that number handy, and I don't believe it was addressed in Mr. Olcher's deposition, so I don't think it's in the record, but I don't know that for sure, Your Honor. But
Mr. Murphy,
I think
can we go? I'd just like to go back for a second to the question I asked you before, because I'm still trying to understand what this otherwise participate covers. And some of the examples you gave me, I think most of the examples were things covered by the first term. So what would be excluded by that language? What would not be included in that language, but only encompassed by otherwise participates?
Well, I don't think that the cells would necessarily cover the instance of a demonstration unit. For example, you go to Kia to take your car in for repair, and they give you a loaner or a demonstration unit. That would not be a sale. That would not be a lease. That would be like some sort of a licensing arrangement. So that would be an example. Something like Cars to Go, where you would have a license to use a car for a couple of hours, perhaps.
Isn't that a lease, essentially?
I don't think that's how a lease is conventionally understood in the car area. I think that's more of a licensing arrangement. But the trademark licensing examples I gave, Torres versus Goodyear from Arizona, Castle versus Remington Arms, those are situations that did not involve a sale, a lease, preparing, blending, anything like that, where the court said there is such extraordinary involvement in the creation of a market for this product and in influencing the design of this particular product that they are going to be treated as a seller under 402A. I don't think those situations would be encompassed at all by the first 7 terms. I can see how that sort of extraordinary involvement, which is way beyond anything any internet marketplace provides, how one could think that that might fall within that term. So it's not a null set. We're not up here contending that otherwise participates is a null set. So I think the critical thing, though, is that promotion and these concepts of neutrality or indispensability, those are nowhere in the statute. And if those were read into the statute, one, that would be contrary to legislative intent. The intent of the General Assembly in 1988 was actually to restrict liability, restrict supplier liability, not to add new components, not to return or not to go into some sort of a vague multi-factor policy notion of what a supplier is. And that was along the lines of what other states were doing. In fact, about half the states now have some sort of protections for sellers, because as is evidenced in House Bill 1's legislative history from 1988, as is reiterated in Senate Bill 80's history or uncodified portion from 2004, there has been a widespread reaction to the idea that there should be an expansion of liability. The history of strict liability from the 1960s and 1970s is a retrenchment of liability and a recognition that things went too far. And that makes sense, because if we were to expand liability based on promotion or on vague policy notions of being able to compensate or have some sort of ability to do something with the product, that's practically limitless. Imagine companies like DoorDash, Grubhub. Those are entities where you go on, you put in a search, you might search for an Italian restaurant, and it gives you search results, and you choose among them, and they process the transaction, they handle the communications, you're conducting the entire transaction on that website, on that marketplace. And if the court were to adopt the liability rule proposed by the plaintiff, or to read something new into OPLA, who knows where liability would end? It's practically limitless. So to address a couple of the cases, or actually, I wanted to address a couple of the things that plaintiffs said that are factually inaccurate. One is Ken Olcher, the president of Tencoris, was very clear that you can communicate with, that Tencoris could communicate with users on Amazon.com. That's at record 282, pages 97 and 134. Amazon provides the buyer-seller communications tool. The buyer and seller absolutely can communicate with each other. If you just go on Amazon.com, you can see a button saying contact seller. This idea that Tencoris had no access to any information about its own product is also unfounded. The safety information that plaintiff is talking about is in the customer reviews that are published on Amazon.com. Everybody has access to those, including Tencoris. And this idea that Mr. Jones testified that there is no investigation or response to third-party products is unfounded as well. That's in record 326, page 55, where he was clear that the product safety procedures absolutely do apply to third-party products. In my last 25 seconds, I will just conclude. The General Assembly balanced various policies and decided who can be liable and under what circumstances. OPLA does not permit supplementation with promotion or other vague notions of policy or other things like indispensability. The Ninth Circuit correctly held that Amazon is not a supplier of a product that it did not sell, package, label, or touch. Thank you.
Counsel, you have about 2.5 minutes.
Thank you, Your Honor. I'd like to touch immediately upon Kelsey Kidd's testimony.
Before we get to the testimony, if we accept your understanding of otherwise participate, why did the legislature put the first 7 terms in there at all? Why not just say whoever participates in the placement of a product in commerce is?
I think the reason that they placed that there, Your Honor, was because times change. in terms of business transactions, they change.
Right.
So
But
it was
that
a
would
catch-all.
counsel for leaving out the first 7 terms and just say whoever participates. If we take
It's not an and, it's an or, it's a conjunction. So what they did know at the time that they wrote that statute were what they listed. And in terms of or otherwise participates, this product does not get into e-commerce without Amazon's participation. Going back to
right, but I think you're missing the point. Why would you need to put everything else? If times change doesn't help your argument. That's the other way.
I think they also followed this court's unanimous decision in Anderson. They used the exact same language that the court used in terms of stream of commerce. So in terms of that, they followed the exact same language that this court used. In terms of placing in the stream of commerce, the result on the A9 patented algorithm, they selected each of the products that Kelsey Kidd said. Her testimony was that she put pre-workout on it, and underneath it, it says products you may like at the bottom, and it was one of those products. She didn't have to go any further than that. Any of the products that she saw were selected by Amazon. And then that started the placement into the stream of commerce, because then she decided to purchase that product which had been listed. Then she had to complete that purchase through Amazon. She wasn't allowed to leave that website. So they control that entire.
Well, counsel, I asked Mr. Murphy what were the methods by which Tencoris can't, distributed or sold its product. They have their own website. eBay carries it and Amazon carries it. There may be other places. I don't know if that was an exhaustive list. So when you say that she was restricted or could only get this product from Amazon, that's not accurate.
Well, actually, she could have bought it somewhere else, but she was on the Amazon website. It doesn't take her anywhere else. Amazon controls that. And based on the discovery in this case, the majority of the sales were through Amazon. There were over 1,500 in the state of Ohio alone on this product over a 4-year period.
Okay, do you know the answer to the question I asked Mr. Murphy about whether Tencoris, what's the proportion of their sales, from their website, eBay to Amazon?
Yes, Your Honor. In terms of the discovery request and answers to interrogatory, the large portion was on Amazon.com based on the
what does that
responses.
mean, large portion?
Well, in terms of it, I would say it was probably between 75 to 80%, if my memory serves me correct. And as soon as Amazon no longer allowed them to sell this product, they had to file for bankruptcy because they were not able to bring any of the sales drop that dramatically for all of their products, not just this one.
Do you think that was related to the safety concerns or the fact that Amazon it's probably both.
They had other products though. It wasn't just they were selling other products than just this pure caffeine powder with Amazon as a selling partner. And in terms of the algorithm and what was mentioned by Mr. Murphy, Amazon is the only one that has an algorithm that pulls up the safety concerns and alerts their product safety team to any potential safety concern. And if it's a product that's Amazon is the seller of,
is there just like some line here that if an internet web service does a really good job or does a few more things, it crosses that? So eBay's on one side, but if eBay provided a few more services, then it'll become a supplier. And what is that line?
I think we specifically have to look at the facts of each of the cases and the control that they have. And Amazon had total control in this case. And over the transaction, over the selection, they totally control what is on the website. They have the ability to immediately halt a sale, to stop a sale, to take down a product when they know that it's dangerous.
Counsel, did the promotional fee that the manufacturer paid Amazon play into the algorithm that brought it to the screen in the search?
In terms of what they paid, no. The only thing that the algorithm A9 is concerned about is the ratings that it has, whether they deliver the product on time, and if it's the lowest price. And actually, in based on the relationship that Amazon had with Tencoris, they actually Amazon sent 10 Course an email suggesting that they lower the price on their pure caffeine powder. So that goes to another control issue that Amazon has. And that's in 10 Course base number 22386 in this case. So
Thank
with
you, Counsel. You've used your time.
Okay, thank you, Your Honor.
Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision. Oh, good. All right, our next case is 2019-601, the State of Ohio versus Dennis Hackett. For the appellant, we have Mr. Hardwick.
May it please the court, Chief Justice O'Connor, I'd like to reserve 5 minutes for rebuttal. While there is no standalone right, quote unquote, right to stand by counsel, part of a trial court's job under the Sixth Amendment is to determine the parameters of what standby counsel should look like. And both this court and the United States Supreme Court have stated that, have so stated that. The United States Supreme Court on page 174 of McCaskill said that the counsel clause implies a right in the defendant to conduct his own defense, comma, with assistance. This court in the syllabus in Martin, interpreting both the Ohio and the U.S. Supreme Court, U.S. Constitution said similarly that the defendant has the right to, quote, conduct his own defense with assistance. Excuse me, that was, this court said that with the assistance of standby counsel. In this case, the trial court was unequivocal on the record and told Mr. Hackett that his standby counsel's only job was to be prepared to step in and become the lawyer should Mr. Hackett change his mind. Nothing more, nothing less.
Counsel, what was the actual prejudice from the lack of standby counsel?
There were a number of problems in this case. First of all, it's important to note that the trial court found that the rape charge was, he said he was, quote, quite candidly struggling with the Rule 29 motion. That was on page 740. Mr. Hackett tried, for instance, to get in a witness who was standing in had been in the courtroom, but didn't actually issue the subpoena, so the person couldn't testify. He had thousands of pages of cell phone records dumped on him just before trial, and he wasn't able to look. He asked for some assistance in looking through them. He didn't even have a computer to look through them. He was unable to do so. Those were the two biggest examples. This case depended on cell phone, largely, a large part. There's a lot of cell phone records. There was DNA evidence, complicated evidence. But I also suggest that generally the rule for when someone is completely denied assistance when they should have received it is that we look at that error as structural, because in most cases, it becomes difficult to determine what would have happened if that person.
Counselor, so you say that the Constitution, the United States and Ohio Constitution, gives a criminal defendant the right to have standby counsel?
They have, and that is part. Yes, that is part of what a trial court must decide. It's not absolute. The trial court has discretion to shape the role of standby counsel, but the most important. But if this court can issue syllabus law, I would say that a trial court cannot arbitrarily limit the role of standby counsel. It's the position of the state and its amicus that it's okay if the trial court is arbitrary, unreasonable, and capricious in the denial. And that is simply not consistent with what the United States Supreme Court has said.
Well, but to go back, so you said yes, the United States Constitution and the Ohio Constitution do require a trial court to provide standby counsel. That you say that's a constitutional right?
Yes, although it's not absolute in the way that the right to have your own lawyer is absolute, because the McCaskill and Ferretta and Martin, do give the trial court discretion in how to shape that. And I think it's important to note that Mr. Hackett's motion for standby counsel is taken almost word for word from McCaskill and Martin. He researched the law.
Okay, so if you say, I'm not sure, I'm still not sure whether your answer was yes or no to my first question, but you do admit that the trial court has a right to limit or to say how that works, how standby counsel should work, not in an arbitrary way. So really, there is no defined set of rules or regulations or standards for the trial courts to use uniformly. It's just whatever the trial court thinks the defendant needs. And is there any way, secondly, any way for the defendant to know what exactly he or she gets with standby counsel?
Well, the U.S. Supreme Court has given guidance to trial courts and has told trial courts certainly what they can do. And they can do substantially more than what the trial court in this case thought. The U.S. Supreme Court has said that standby counsel can go as far as arguing for the defendant outside the presence of the jury, as long as it doesn't, and this Mr. Hackett put it in his motion, as long as it doesn't change the perception or reality that the defendant is in control.
Then how do we review what's enough? How do we review whether one trial court judge permitted standby counsel to do more than another trial court judge permitted? I mean, what's our guidelines? What are our standards?
I would say that as the case is presented even by the Attorney General show, the standard is abuse of discretion. Is the decision unreasonable, arbitrary, or capricious? And that is a high burden, but here we can meet that in two ways. First of all, the trial court said that it was without authority to give Mr. Hackett what he asked, even though he was basing it expressly on the language of the United States Supreme Court. And even if this court found that, and certainly part of what he was asking for was, and part of it was even stronger, he just asked for someone to be able to whisper in his ear at counsel table, to consult with a counsel table in a way that still would have left him completely in charge of his case.
And so didn't he actually ask for basically co-counsel? And is there any right to have a co-counsel in place?
No, he didn't ask for basically co-counsel because he based on what the U.S. Supreme Court said, and the U.S. Supreme Court said that isn't co-counsel. But even if this court found that I think he asked for 5 things and 3 of them were he shouldn't have got, he still asked for even the 1 or 2. Just because someone asked for 5 things, if the trial court determines that 3 of them are valid, 3 of them are invalid, and 2 of them are valid, they still should give them what they are entitled to. And the important thing in this case is, throughout this entire litigation, neither the state nor its amicus have been able to show this court any reason why a trial court would want to deny this right, would want to deny counsel to be sitting there at the table. I mean, the prosecutor interrupted trial, according to the transcript, 16 separate times to go consult with each other. The court reporter noted it. There's no reason why Mr. Hackett could not have done something similar. And if the state can't even give a reason why it's a good idea, now I understand that the state makes non-frivolous arguments when it comes to the technical argument. But when you get underneath those technical arguments, you see a reality that there's no good reason not to do what Mr. Hackett asked for. It's simply arbitrary and reasonable capricious, and this court should not stand for that.
Counsel, are you saying the major flaw here was that his counsel was not, his standby counsel was not allowed to sit at the table with him? He was in, I guess, the back of the courtroom, correct?
Correct.
So
or in the courtroom. I don't know if the back of the
Pardon
courtroom, but in the gallery. He was in the gallery. I don't know if he's in the back of the gallery.
All right, but he was not able to converse with him unless there was a recess called or some other method.
Well, first of all, there's nothing in the record to show that that the parties ever violated the trial court's order that said nothing more, nothing less. but also on page 22 of the transcript, and I miscited the page in my brief. I said page 33, but it's on page 22 of the voir dire. The trial court expressly said that Mr. DeFabio was in the courtroom, quote unquote. Now, you wouldn't say someone was in the courtroom if they were sitting at counsel table. They also, at all the times you would have expected that Mr. DeFabio's presence be mentioned as him being at counsel table, there was no mention. There was no mention of the jury instructions about him being there. When they introduced everyone to the potential jurors during voir dire, they introduced both prosecutors, the detective at counsel table, and Mr. Hackett. No mention was made of anyone else. And they never mentioned him playing any sort of role other than a mere ministerial role of trying to secure a specific photograph from a specific vantage point that Mr. Hackett.
Mr. Harwick, all that may be true, but I guess I'm struggling if there's no right to stand by counsel, how any of those things could possibly be a violation of his right to stand by the counsel or the Sixth Amendment or anything else.
Well, it's because what the U.S. and the language of McCaskill it does say is the right that the right to the assistance of the Sixth Amendment, quote, implies a right of the defendant to conduct his own defense, comma, with assistance. That's McCaskill. So they did say with assistance. Now, I think the state does point to a whole bunch of cases involving ineffective assistance of so-called ineffective assistance of standby counsel. And I'd agree there's no claim there because when he is the ultimate decision maker in his case, he takes responsibility for it's his performance that's deficient in the end. So there is no such thing as ineffective assistance.
So are you saying there is a right to standby counsel, contrary to what almost every circuit has said?
Yes, and even if this court decides the answer that it's not a standalone right, it is part of the analysis that trial courts must go through. The U.S. Supreme Court has said that the next step when someone waives the right to counsel is to decide, well, whether to allow standby counsel. And that's being given to the discretion of the trial court. The standard of review for discretionary decisions is abuse of discretion.
But the court, but clearly the court could have said you don't have any right to stand by counsel at all, right? We don't disagree with that.
Well, the U.S. Supreme Court could have said that. They haven't said that.
No, but the court in this case could have said you can't have standby counsel at all. You think it's incorrect as a matter of Sixth Amendment law?
I think that would be, unless there was generally that would be an abuse of discretion. I can't fathom a situation where that would not be arbitrary and reasonable or capricious, because again, there's no reason.
Help me with that. I've never seen just a generalized abuse of discretion claim. Generally, abuse of discretion is tied to some area of the law where the judge is given discretion. I've never seen a standalone claim. So it seems like, well, that's what you're arguing for here.
Well, the U.S. Supreme Court has mandated, and this court in Martin has told trial courts they have to decide the role of standby counsel. That's part of the Ferretta process. So it is not. So yes, that is where the mandate comes from. It comes from both this court and the U.S. Supreme Court. When the U.S. Supreme Court says conduct his own defense with assistance, and this court says that he has the right to proceed pro se with assistance, that tells me that yes, the trial court must at least think through that. Now, if Mr. Hackett had been disruptive at counsel table, that may have changed things. But there is
Counsel, are you saying that if the court's going to allow standby counsel, it has to be a meaningful allowance of standby counsel, and here it was not? I'm trying to understand, based on Justice DeWine's question, what exactly was the abuse of discretion? And how would you characterize it? That yes, the trial court allowed for standby counsel. However, it was a sham. It was meaningless because of the restriction, the way the court fashioned the role of standby counsel.
Yes, in this case, yes, it was meaningless. It was utterly meaningless. It was a sham in this case. it provided no assistance. It was simply his role was to be there ready to jump in. And there was no, and it was arbitrary because there was no good reason to do it. And also, you can come back to the trial court thought he could, the trial judge thought he couldn't do this. And that's different from a trial court who thought, well, here, I have this range of decisions from here to here. Where am I going to go in there? This trial court thought that he had no discretion at all. And so he said, no, you can't have any help at all in any way, shape, or form. And that is clearly not the law. And, Your Honor, at that point, I think at this point I'm going to stop with, except to reiterate, the state has never given any good reason why a trial court would do what this trial court did. This court should reverse and send this back for a new trial. Thank you.
Thank you. Counsel, is it Mr. Rivera's going first?
Yes.
Okay.
Chief Justice O'Connor, may it please the court. Attorney Ralph Rivera on behalf of the state of Ohio and the Mahoning County Prosecutor's Office. I will be sharing my time with Attorney Stephen Carney from the Attorney General's Office. This case is plain and simple about the Sixth Amendment right to stand by counsel. The case law is clear that there is no Sixth Amendment right to stand by counsel. And because there is no Sixth Amendment right to stand by counsel, there is no residual right to have standby counsel do any single task, regardless of how minimal it might be. As the Sixth Circuit in Wilson versus Parker discussed, to the extent that standby counsel failed to do any particular task, the defendant merely suffered the consequences of his decision to proceed pro se, similar to an invited error standard.
Counsel, when someone, if standby counsel is deficient in what they're doing, and that's a decision of standby counsel, in other words, they're determining their involvement or they are involved and it's, deficient. That's not the same as the court fashioning the role of the standby counsel and merely appointing it and then not allowing for anything further. In other words, it's just waiting to see if it was necessary to step in, I guess, is what the thought was. Do you see the distinction there?
Yes. There's a distinction between that decision to appoint standby counsel, and then once standby counsel is appointed, there is that area of what standby counsel is doing or not doing. In this particular case, the trial court, there's no issue of an abuse of discretion. It was never raised below. It was never dealt with at all with the 7th District. What the trial court does not have discretion, while they have discretion to maybe appoint standby counsel, Mr. Hackett clearly requested co-counsel. He clearly requested hybrid counsel, and the trial court does not have discretion to allow that. And that is based on the clear language in Martin. Going through Mr. Hackett's motion, he asked for active assistance. He wanted Attorney DeFabio to advocate on the record whenever possible. He wanted, again, to speak on the record to advance his legal and procedural matters.
Counsel, but wasn't the defendant prohibited from even turning to their standby counsel and just asking a question privately out of earshot of the jury? I mean, isn't that the equivalent of just not having standby counsel at all if you're not allowed to do that?
I just, to clarify the record, there is nowhere in this record where the trial court, where Mr. Hackett specifically asked the trial court, can I talk to Mr. DeFabio at any particular time? That question was never asked, and the trial court did make the statement of nothing more, nothing less to kind of give that impression. But again, it's not on the record, but there was numerous times during this trial where there were conversations, and the record does not reflect one time where Mr. Hackett said, or asked the trial court, can I have a recess to ask Mr. DeFabio a question? the record is clear, and the 7th District found that there was never any time on the record where the trial court clearly prohibited Mr. Hackett from talking to Mr. DeFabio, and that's really the main argument.
Do you think, counsel, do you think not having standby counsel at the trial table prohibited the communication during the trial?
It did not prohibit the communication during the trial based on, again, it's not in the record, but based on the closeness and proximity from defendant to Mr. DeFabio during the trial.
So what are you saying? How close was he in the courtroom to him?
I would probably say within 10 feet. I think.
Okay, can you say that a defendant could ask an attorney a question if they're 10 feet away?
He could definitely ask the trial court for a recess. And again, I think we're talking about if the
well, then the 10 feet does not matter at all. He could have been in the back of the courtroom and asked for a recess. So that doesn't matter how close. If he wasn't at the trial table that allowed for a communication, as I think is what he wanted, he probably wanted more, and that was not allowed by the court, of course. But the fact that he was, I guess, shut out of the whole process, basically, by the positioning is troubling.
I think, and just to clarify, Mr. Hackett, again, never once asked for trial counsel to sit at the trial table. There's nowhere in the transcript. The closest that Mr. Hackett comes to asking for that is in his motion. He claims he has, and quote, defendant has the constitutional right to have standby counsel seated at counsel table. Again, I don't think anyone's contesting that there is no constitutional right to actually have him.
Right, eliminate the constitutional basis, but he was asking for trial counsel to sit at his table and the judge denied it.
Well, again, the trial court never specifically denied that request.
Well,
he never, the trial court never.
Did the trial court rule on that motion?
Yeah, the court did deny the motion based on what the 7th District also found. The trial court found the 7th District agreed that his motion was for hybrid counsel. That is what.
Even just sitting at the table at the trial table.
Merely sitting at, I would agree that merely sitting at trial counsel, or I'm sorry, at counsel table is not hybrid counsel. But again, that is not what Mr. Hackett asked for. Mr. Hackett asked for, his motion is entitled full assistance of standby counsel.
But what does that mean to you?
Well, I mean, to me, the trial court and the 7th District all found and concluded that Mr. Hackett was requesting hybrid counsel, which is clearly prohibited, which the trial court would not have any.
Well, but again, full assistance of standby counsel and hybrid counsel. How does a defendant know the difference? And would you concede that the assistance of standby counsel varies from trial court judge to trial court judge?
Yes, I would. Yeah, I would concede that.
Then how would a defendant know what this particular judge would allow in the full range of assistance of standby counsel?
I think the only way you can do it is where you have, as Mr. Hackett did, ask for specific things in his motion. He laid out specific tasks which he was asking for, which all of them amounted to hybrid counsel. He was clearly asking for Mr. DeFabio to take an active role in the trial. That's what he wanted, and that's what he was asking for. And that's really the difference. And I think it's one of the main issues in this case, and that is what the trial court denied. The trial court, again, clearly never stated on the record. There's nowhere in the record where the trial court said Mr. DeFabio cannot sit at trial table, and there's not one instance on the record. There's several different pre-trial hearings. There's a discussion before trial. Again, Mr. Hackett never asked for Mr. DeFabio to sit at trial counsel table, and it goes back to what the trial court denied was hybrid counsel, and that was specifically what Mr. Hackett was asking for.
Well, counsel, didn't you just say to me that he put a motion on saying it was his constitutional right to have his counsel at his table?
I'm saying that is the only instance where Mr. Hackett even mentions the word.
Okay, he uses the wrong basis by saying it's my constitutional right, but that was a request to have the attorney at his table.
I guess I would analogize the request as kind of a motion in limine. He asked for the request. He asked for this. He asked for very specific things in the motion. The trial court denied it and explained to Mr. Hackett why the reason he denied it was because he was asking for hybrid counsel. That's all on the record. And he goes, and those are clearly.
But sitting at a table is not the definition of hybrid counsel.
No. But he's talking about, the trial court was talking about the specific actions that he was requesting.
And the court could have said, I'm not going to let your standby counsel do any of what you just asked, and still allowed him to sit at the table.
I think if Mr. Hackett would have specifically asked the trial court at the hearing to clarify whether counsel could even sit at trial counsel, I think we'd have that answer, but that never happened. That issue, we have no idea whether, again, at the end of the day, we don't know if Mr. Hackett actually wanted that. He put it in his motion, but again, a very vague reference. But again, I would, with my time running out, I would concede the rest of my time to Mr. Carney and ask this court to affirm the 7th District decision. Thank you.
Mr. Kearney?
Good morning. May it please the court. I'd like to supplement the state with 2 types of points, doctrinal and practical, that show that the 6th Amendment, by not requiring standby counsel at all, also does not require standby counsel to act in any particular way, and told otherwise would be both unwarranted and unworkable. On doctrine, I want to briefly touch on case law, but mostly focus on the role of prejudice that Justice Fisher asked about. On the no right to standby counsel on the case law, yes, Martin does have some ambiguous language that standing alone might suggest something about standby counsel. But if you look at it in context, and especially at the follow-up case of Obermiller, we see that in Martin itself, the court says 2 things: that it's permissive, not required, and that the 2 rights, the right to have counsel or to go it alone with self-representation, cannot be asserted simultaneously. And what Mr. Hackett is doing here is literally asserting both simultaneously. He's saying, I want self-representation, but I also want to still claim basically an ineffectiveness claim by another name. When you say,
Mr. Carney, again, and I asked Mr. Rivera, I think, this question: how does a defendant know where he or she crosses the line with standby counsel and hybrid counsel?
Well, there are two answers to that, Your Honor. First, in this case, if you look at particularly the January hearing, when the trial court first engaged in an extensive colloquy, and he says, you're going to have trouble formulating questions. Attorney DeFabio is going to be there only to step in if you change your mind. And there's a later one, it's either the February or March hearing, where Mr. Hackett asked the trial court, so wait a minute, I can only talk to him if I give up my right. And so he was told this is how it's going to be.
So what that really said was the trial court saying, you represent yourself or you have counsel. Because if you say you'll have trouble forming questions and your lawyer will only be able to step in if you change your mind, that's not standby counsel. That's either you do it alone or you are represented by counsel.
Well, 2 things about that. First, the term of art, standby counsel, really encompasses 2 notions. One, what the court here did was true standby to step back in if the self-representation ends. The other form is really advisory counsel, to be advising as you go, and that's what he's asking for. And while that is an option, what he's asking for is to take what McCaskill called the maximum allowed of even offering advice, even doing this and that, and saying that maximum is a minimum. And that's both doctrinally wrong, but it's also where the practicality problem comes in, because it's impractical to say you have to walk this tightrope, both as a court and as the counsel who's appointed, to say, if you go too far and are too active, McCaskill says that violates the right of separate self-representation.
Counsel,
But here,
did the judge understand that he had more than the model that he used, and he could have had counsel at the table and there just be maybe an exchange of notes or whispers, but not the standby counsel was not addressing the jury, was not questioning witnesses, was not addressing the court?
well, there are two ways to look at it, and neither way leads to a different outcome here. I see my time's almost up, if I may answer the question.
Please.
So to the extent the court was saying, I can't do that, I can't do what you're asking, it was in the context of Mr. Hackett over asking for the hybrid co-counsel role. The motion was even titled Motion for Full Assistance. To that extent, the trial court was perfectly correct. He could not go as far as Hackett wanted. To the extent the trial court, if the trial court were hypothetically mistaken about saying, oh, I can't do anything, when we concede, of course, Martin does allow it as an option, then it still doesn't create an abuse of discretion here, because one of the elements within that discretion is to say no. So if the trial court were saying, I can't do it, but I'm not giving it to you anyway, I prefer you to do it only this way, that's a perfectly valid choice. And I know my friend on the other side said, oh, the state didn't give a good enough reason. Well, first, he's asserting a right. Frankly, we don't need to give a reason, but also there is a good reason, and that is to not try to make it too easy. It is a valid reason to discourage self-representation. That's why we do a colloquy that says, are you sure you really want to do this? Here are all the problems ahead of you. And one of those is, this is not going to be easy. I want to mention, if I may answer briefly about prejudice, Justice Fischer asked about prejudices here. Prejudice in even a Strickland case, when you have full counsel, you have to show not just this evidence got in or this evidence wasn't admitted. You have to show an ultimate prejudice of a reasonable probability the verdict would be different. And here, with the DNA evidence of the victim's blood on his pants, with the GPS putting his phone in the area of the body, with all of that overwhelming evidence, this was not going to come out the other way. And what he asserts is prejudice of, oh, but look how I formulated questions wrongly. That's basically true in every self-representation case, that they do something that they could have done better with a lawyer. After all, it doesn't say much about our profession if having counsel there would not have improved over what someone did flying solo. And to give him a standard where he doesn't have to show prejudice at all, where he gets an automatic do-over, where everyone else with full counsel, would have to show prejudice, is absurd. It distorts the incentive. So it's both doctrinally wrong and impractical. So
Thank you.
thank you, Your Honor.
Counsel, you've used all of your time. You may take 30 seconds.
No.
Mr. Hardwick, your mic is off. You're muted. There you go.
Thank you, Your Honor. It is not the job of a trial court to discourage self-representation. It is the trial court's job to inform a defendant of the consequences. And in this case, Mr. Hackett treated the trial court with dignity and respect at all times. He asked for a lawyer to help him sit at counsel table in his motion. It was denied. He asked for clarification of the trial court's ruling. He got it. Nothing more, nothing less. He then proceeded with respect for the trial court's ruling and proceeded with the rest of the trial with dignity and respect. And the trial court's decision in this case not to allow him to have someone just to even whisper to was an abuse of discretion. And I ask this court to reverse and remand.
Well, counsel, if you address the prejudice, the reasonableness that the trial outcome would have been different, given the evidence.
Well, I did say, and the trial court, and the trial judge who heard the case did say specifically that he thought that the evidence, that it was a close call on the sexual assault charge, especially on the use of force. And then in the state's theory tied in the aggravated murder charge was in the course of fleeing from or conducting the sexual assault. So those two are inextricably linked, and the trial court said there was a difference. But also, the standard usually for a constitutional right is if there was an error, was it harmless beyond a reasonable doubt? And here it was not. And that's what that by itself, this court should reverse. Also, as I said before, I think the better standard is chronic, where this is denied arbitrarily. The usual standard is to allow, to consider it structural error and to reverse when a trial court acts so arbitrarily.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision. All right, our last case this morning is 2019-621 In Re MH for the appellant, Mr. Kuzmans.
Thank you, Your Honor. Good morning, Your Honors. Chief Justice O'Connor. My name is Paul Kuzma on behalf of the child in this case, MH, and I would like to reserve 4 minutes for rebuttal. In this case, we have a compelling situation where a 13-year-old child is separated from his mother, driven to an unfamiliar building with unfamiliar surroundings by his mother, then separated, told that there was a conversation that was going to be private. And that conversation took place in a room with closed doors. The 13-year-old child wasn't told the nature or the purpose of the questioning and the interrogation, and he was never informed of his any constitutional rights or any rights or the right that he had to walk away and not answer questions. And based on this, this court is presented with the question of whether or not statements made under this situation by this child were a product of, were not coerced, were not suggested, and were not a product of his ignorance of his rights. And that's not my language. Those aren't my words. This is the United States Supreme Court in Re Galt. They say in discussing constitutional rights for juveniles, and statements made by juveniles without the assistance of counsel, they say that we need to take great care to ensure that statements and admissions were not the product of coercion, suggestion, and not the product of ignorance of rights or adolescent fantasy, fright, or despair. Yet that is exactly what we have in this case. Now, a lot of the facts that we're going to be discussing today overlap between these two different areas that we have. We have our Fifth Amendment issues and whether or not Miranda should have been given. And but first we have our due process component and whether or not these statements were made of MH as the child's own free will. And I want to say that these facts oftentimes will overlap, and especially when it comes to looking at custody analysis for Miranda and whether or not the child felt free to walk away or terminate the encounter that he had here with this social worker that his mom had prearranged with him. But looking first to the tradition.
Counsel, isn't a preliminary issue whether or not Ms. Bradley was an agent of law enforcement?
Only as it relates to the Fifth Amendment, only as it relates to the Miranda issue is whether or not she's a state actor. By all accounts, and it would be a prerequisite under Jackson for the Miranda analysis. And I think that under that analysis, she clearly is, in fact, operating as an agent of law enforcement. But what I want to say first about Jackson is I don't think Jackson paints the exclusive test for determining when a state actor is a law enforcement or acting on a request of law enforcement. It provides part of the test, and it was adopted from Bolden, which was a case involving a private citizen acting as store security. And in that case, the language relied on in Bolin and now in Jackson was this idea of, controlling the investigation, having some sort of control over the investigation. And I think that what makes that, but that's an incomplete test. And Bolin even recognized that. In Bolin, now first a couple things about Bolin. It came down in 1971, and it predates a lot of the other cases that this court has interpreted Miranda in, and it also predates a lot of the cases that are relevant under Ohio or U.S. Supreme Court precedent. But even in Bolin, they recognize that employees of government agencies who, with the function of enforcing the law, are one person who needs to require Miranda, are a group of people that need to give Miranda warnings, in addition to those acting at the direction and control of law enforcement.
Counsel,
Yes.
The social worker was mandated to give her report to the police. Is that a true statement?
Yes, but I think it's only part of the truth. She's also mandated to investigate cooperatively. And I think that there's a difference. That's an additional obligation that is presented. The statute in this case requires not only kind of mandatory reporting, but it also requires mandatory investigation. And a mandatory investigation is done in cooperation with law enforcement. And now, returning to the Bolin.
Well, let me just stop you for a minute.
Yes.
My understanding is that she turned her report over to the detective, and they did not question your client, MH. The detective did not. Is that correct?
That's correct, Your Honor. In fact, the detective didn't do any investigation in this case, in the formal sense of how we would normally think of an investigation. It was Bradley, the Children and Family Services investigator, who, number one, instructed that the alleged victim's mother file a police report, and then interviewed that child's mother. Excuse me.
Counselor, if the detective had done some investigation after getting Bradley's report, would you still be arguing the same error?
Yes, I don't think that simply because the detective does some additional investigation that it insulates the social worker from having to give Miranda warnings under these circumstances. The social worker here did all of the investigation, though, and I think that's extremely important, and one of the big differentiations between this case and Jackson as well. But I do want to reinforce this idea that Jackson is an incomplete test of sorts, because again, this court found in Roberts that a probation officer who is an agent of the judicial branch is required to give Miranda warnings when they question a probationer who's in custody. Not a probationer who comes in as a part of a routine visit, okay? But when they are brought into custody. And in Roberts, Roberts was arrested as part of after a search warrant was executed at his girlfriend's house. The probation officer was phoned up. He met the police he met his probation officer, probationer Mr. Roberts, at the jailhouse, and then interrogated him. And important, though, in that case is your rationale, the Ohio Supreme Court's rationale talked about the probation officer, that it's a unique relationship where the client trusts the probation officer, often, not always, but oftentimes trusts the probation officer. And because of that trust, that there's a ripeness for abuse. Not unlike the trusting relationship here that our client would have with his mother, who turned him over to the social worker, or that one might intuitively have when talking to a social worker who says this is going to be a private meeting. This court also in Roberts recognized that one of the overarching principles in Miranda is to protect against the appearance of deception. And we have tons and tons of deception in this case, beginning with the social worker's deception with mom, continuing through her lack of candor with the child in this case. But Roberts isn't the only authority. Okay, Roberts isn't the only authority that shows that Jackson isn't the end-all be-all on when a law enforcement or when Miranda needs to be given. In Gallagher, this court found that a parole officer also, when interviewing somebody on parole, needs to give Miranda warnings. And again, they talked about the heavy psychological pressure placed on an adult parolee, the heavy psychological pressure placed on them by this unique relationship. And also, like the probation office, there is often a trusting relationship, and it's assumed oftentimes that the parolee may think that his or her comments to her parole officer are being confidential. Again, we have that situation here as well, don't we, where the probation officer, the social worker, assures mom that this is a private conversation, affected deeply.
So did the mother know what the subject of the conversation was going to be about?
So she had her inklings. That's right. That's what she says. She says, I kind of knew. I knew what the allegations had been made. I knew what was going on. There's no evidence that she knew that this was a criminal investigation of any sort. There's no indication that she assumed that this social worker was conducting a criminal investigation of any sort. This was a consensual sexual relationship between a 12-year-old and a 13-year-old. And I don't think there's any suggestion that mom believed this was criminal, but she said that she had a hunch, that she kind of knew what it was about. She is steadfast in her insistence that she was never told by the social worker what it was about. And now the social worker has a different story. But moving on again to show that Jackson isn't the end all be all, we also have Estelle, which was addressed in Jackson, but it's the psychiatric examiner, the court-ordered psychiatric examiner. And I think what's critical there is the Supreme Court relied on the use of the statement, how that statement was going to be used to determine that it should have been Mirandized. And Mathis is a tax investigator case where the tax investigator was found to be operating such that he or she had to give Miranda warnings. And interesting there is the Supreme Court rejects two arguments that are very similar to the arguments made by the government in this case. There they reject this idea that in the IRS case, in Mathis, the government had argued that, well, we weren't sure these charges were actually going to be taken criminal. It could have been just subject to a civil proceeding. And because the statements could have only been subject to a civil proceeding, that they didn't need to be Mirandized. And the Supreme Court rejected that argument. Also talked about that because Mathis was in jail for an entirely separate offense, then he was being questioned about that it wasn't, I guess, custodial. And again, that was rejected as well. There, the court said that these differences are too minor and too shadowy, justified departure from the well-considered conclusions of Miranda. So again, I think that Jackson isn't the final word on all of the tests. It's not the exclusive test for when Miranda is given. But even following the test that is announced in Jackson, this case is different in many regards. One we've talked about in the sense that this is a case where the social worker did the entire investigation. Unlike Jackson, in Jackson, the detective actually went to go interview Mr. Jackson in jail. And then I think it was 5 days later that the social worker went. That's evidence that these are two parallel investigations going on, that this wasn't in one singular investigation, like our case, which is one singular investigation. We also have evidence of the exchange of voicemails in our case between Detective Cottom and the social worker. But I also think equally important is the fact that the memorandum of understanding between law enforcement in Cuyahoga County and Children and Family Services mandates that if the law enforcement wants to be the solely in charge of interviewing any alleged perpetrators, that they need to let the Children and Family Services know that within 10 days. Underlying that is the assumption that the Children and Family Services investigation is kind of the point, running the point, especially as it relates to interviewing perpetrators, that they will either, Children and Family Services will run the point or will be done in conjunction with law enforcement.
So are you saying that that's the reason that the interview took place by the social worker, to be the shill for the police?
I don't know. Yes, I think that. So
every time a social worker interviews someone in a situation where there is a potential criminal activity, even though they're mandated to turn that report over to the police, they're an agent of the police, because we haven't found that.
No, you haven't, and I don't think that Jackson makes clear. Jackson makes unequivocally clear that the statute that requires cooperative investigations and requires mandatory reporting, Jackson makes clear that does not automatically remove this under the purview, put this under the purview of the Fifth Amendment. And with that, we agree. But when I say, and I don't mean to go along with the word shill, I guess, because here, the institutional relationship between Children and Family Services and law enforcement, and Cottom and the social worker and Bradley in this case, is such that the direction and control that seems to be imagined by Jackson is not going to be found. You're not going to have that overt direction because of the institutional relationship that's there, the pre-existing relationships. And Jackson makes it even, encourages, and in my mind, encourages the gamesmanship in situations where what the government couldn't do through their investigator, getting unwarranted statements, they now can't do through a social worker. Now, the social worker had dual purposes, and often cases they do. In this case, their second justification creating a safety plan is dubious at best because they don't interview the child, our child, MH, for over 2 months. And actually longer when you consider the date of the offense. The alleged offense happened in August, and he's not interviewed, I believe, until December. So there is no ongoing. And also, in what furtherance does a 13-year-old child in MH's situation have to do with the safety plan? Those are questions that are better served for the adults in that child's life and the child. So I do think here the overarching reason for the social worker's investigation was, in fact, the criminal investigation. And I'll reserve the remaining time I have for rebuttal.
You don't have any, but go ahead.
I know, I see that. Thank you.
All right, Ms. Mayer.
Thank you, Chief Justice O'Connor. May it please the court, my name is Jennifer Meyer. I represent the appellee of the state of Ohio in this matter. I'd like to defer the balance of my argument time to Deputy Solicitor General Samuel Peterson. We ask that you affirm the 8th District's decision to overturn the motion to suppress MH's admissions to the social worker. There are 4 reasons why. 1, there is no agency relationship between the social worker and the police, especially Revised Code Section 2151.421, former subsection F1, does not create such an agency relationship that my colleague, Mr. Kuzman's claims exists. Secondly, there's no evidence that the officers had direct control or advised the social worker in her investigation. There's actually evidence to the contrary in the record.
Ms. Meyer, even though they didn't necessarily have to advise or direct, there was an understanding that Bradley would supply the police officers with whatever she got from her investigation, and the police officers did say, be sure we get that information or that we know. There is an understanding of exchange of information, correct?
Well, it's not an understanding, it's a statutory duty pursuant to Revised Code 2151.
Well, that's what I mean. So why does it matter that Bradley wasn't controlled by law enforcement?
Because this court has already determined that the statutory requirements under 2151.421 is not sufficient in itself to create an agency relationship. There must be other factors that create the agency relationship between law enforcement officers and the social worker. If the law enforcement officer had called the social worker and said, I want you to talk to him about this, this, and this, then that would be at the direction and control. But that was not the case in this incident, because the police weren't even aware that the social worker had already interviewed the victim and that she interviewed MH at the time. So there's no evidence in the record that law enforcement influenced or directed or controlled the social worker. Further, there also wasn't a custodial investigation, as my colleague had mentioned, that he had said that this was a custodial interrogation by the social worker. That is not true. There's no police presence at the time. He was not coerced by the social worker. He was not under arrest. Even after his admission, he was still not under arrest and he was free to leave. He was driven to the center by his mother, not by law enforcement officers.
Was he explicitly told, MH, we're here to talk, you can leave at any time?
According to the record, I do not see that he was told that. I am not aware if the mother was told that, but it looks like the social worker testified that she did not tell MH why he was there or he was free to leave, and instead in the interview decided to be more of a friendly back and forth at first and conversation with MH, which is another evidence that it wasn't coerced, that it was a friendly conversation. Third or fourth, the statement by MH was voluntary. It was not coerced in any sort of way. And we look at that by the totality of the circumstances. My colleague in his brief suggested that—
Counselor, how do you discern whether a child makes a voluntary statement?
Yes, Your Honor. So you still have to look at the totality of the circumstances, and the fact that the individual is a minor is one of the factors, but it is not one of the determining factors. So yes, MH was, we believe he was 13 at the time, even though there's some evidence in the record, I'm say 13, 14, that he was 13 years of age, but also his mentality, prior criminal experience, which isn't in the record, we don't have that. The length of the interview, which was only 40 minutes, 30 to 40 minutes has already been determined to be not lengthy in time. The intensity of the interview, we know from the record that the social worker was not coercive or intensive. It was a back and forth discussion. And even regarding the admission.
But I guess when we look at voluntariness, there has to be an understanding that you have an option not to say anything. Is there any evidence that he was told, you don't have to talk to me, you don't have to answer any of my questions, you don't have to be here with me alone, you can have your mother with you?
No, there's none of that in the record that I see. I also don't feel that he has to be told that he has to directly be told that you can leave.
At 13 years old?
Yes.
Okay.
Is that because he's experienced and should know, or why?
I think because his mother, he already had conversations with his mother, and the letter that was sent to the mother said that this was voluntary. When the social worker spoke to MH's mother, also made clear that this was voluntary, but she wanted to talk to him. And she said that she would bring him down the very next day.
And so are you saying his mother told him it's voluntary and you can leave at any time?
I can't say that. I cannot speculate.
So you don't
it's
know.
Not in the record.
There is no record. There is nothing to support the fact that this child knew that, number one, he didn't have to make a statement without an attorney. He didn't even have to sit there and be interviewed.
That's correct. It's not. It is not in the record. That is correct, Your Honor.
Okay.
Also, though, I do want to get back to the fact that the social worker did not make any threat of violence, coercion, or that he was going to be arrested. And the social worker asked him, "Are you sexually active?" She did not say, "Did you do this to the victim?" She asked if he was sexually active, and he said yes, and she asked with whom, and then he said the victim. And so that was more voluntary statement. It wasn't coerced by the social worker. I do want to also touch about something that my colleague had mentioned about Roberts and Gallagher. Those cases are distinguishable in this matter because all of those cases come from parole officers, and all of those individuals were already under arrest at the time. And that was not the case here. He was not under arrest, and he wasn't even arrested after his admission. Also, I wanted to touch on the fact that according to the record, that MH's mother did know about the allegations. On page 18 of the transcript, Initially, she said she had no idea. She didn't know anything about the allegations. And then she backtracked a little bit and said, well, I did know the victim's mother told me about it. There's also evidence in the record to suggest that some other, because this has family ties, that some other family members had gotten involved. And so the mother was aware of the allegations. And there was quite a lengthy conversation, according to the social worker, there was quite a lengthy conversation between MH's mother and the social worker prior to her bringing him down to the
Counsel, did the social worker tell the mother that this sexual activity was illegal?
I do not know, Your Honor. It's not in the record. And I can't speculate. It's not in the record, but I can't speculate if it was done or not done. So if there are no further questions, Your Honors, I would like to defer the remainder of my time to Mr. Peterson. Thank you.
Peterson.
Thank you, Your Honor. Chief Justice O'Connor, and may it please the court. I'd like to make 2 points here this morning, one about Jackson and the other about the due process clause and voluntariness. And I think the second one will answer some of the questions that the court has had already this morning. But first, Jackson. My friend on the other side has suggested that Jackson is incomplete. Respectfully, that's just not true. If the court looks to the syllabus of Jackson, it is unequivocal. It says that the statutory duty to cooperate and share information with law enforcement does not make a social worker an agent of law enforcement. There must be other evidence that demonstrates the social worker acted at the direction and control. If the court wishes to adopt MH's reading of Miranda, it would necessarily have to overrule Jackson. But it shouldn't do that because for many of the cases, for example, Roberts, Estelle, Mathis, that you've heard about today, Jackson already dealt with them. It already distinguished them. It already explained why those did not support the result being argued for. And the same thing, Justice Stewart, you had asked about the obligation to share information between social worker and the law enforcement. Again, Jackson addressed that. And Jackson was a sex abuse case. And so those statutory obligations, memorandum of understanding, those were all already addressed in Jackson. And so if the court were to adopt MH's argument here, it would necessarily conflict with Jackson. But going to the second.
Is that necessarily correct? Or couldn't we look at just the facts in this particular case and come to the same conclusion that the dissenting judge did, that in this case, the sole purpose was to determine whether or not some inappropriate sexual behavior happened between the two of them, and if anything criminal happened, and then to pass that on to law enforcement. It wasn't like there was a situation where the two were in the house and the immediate priority for the social worker was a overall safety issue. They were just wanting to find out what happened and criminal and then pass it over. Do we have to necessarily overturn Jackson?
I think you do, Your Honor, because Jackson said you have to look to see whether there was the direction or control of law enforcement. And here there's no evidence of that. There's no coordination. Any communication even occurred after MH was interviewed. But Your Honor, you quoted a portion of social worker Bradley's testimony, and I think that language has been misrepresented in some of the briefing, because it's not saying that she is seeking to do a criminal investigation. She's simply articulating what her job is, find out what happened, and then what her statutory duty is, convey anything criminal to law enforcement. And so that's not saying that she has a law enforcement purpose. And so I think you would have to overrule Jackson. But I'd like to move on to due process clause and the voluntariness questions, because Miranda already addresses the inherent coercion in a custodial interrogation. Miranda takes off the table any coercion that would necessarily result from a voluntary interrogation. And so what you have to have for an involuntary statement is something above and beyond Miranda. This court in 1988, State v. Clark, said that they're looking at things like physical abuse, threats, deprivation of food, medical treatment, or sleep. And the court more recently in State v. Barker talked about the totality of the circumstances test. And this is the same totality of the circumstances test that the court adopted in In re Watson in 1989. And so it already accounts for age, but it also looks to physical deprivation or mistreatment and the existence of threat or inducement. And now I know in the briefing, MH has argued that JDB somehow changes the totality of the circumstances test, but that's simply not an accurate reading of JDB. I would encourage the court to go back and look at JDB and read the entire decision, both the majority and the dissent. And what you would see is that there is widespread agreement that age is a relevant consideration under the Due Process Clause and under the totality of the circumstances test. The only question was whether age also could be a factor for Miranda and the custodial analysis. And the majority said yes, age did matter for Miranda. The dissent said no, it shouldn't. But both of them agreed that the Due Process Clause already accounts for age. And the court said the same thing in Barker. And so really what you have—
Counsel, how do you think the age of this defendant weighs in here in the totality of the circumstances?
Well, Your Honor, I think it's certainly something that must be considered, but it's also something the 8th District did consider. If you, in the Miranda analysis, for example, which they looked at paragraph 25 and 26 and 32 and 33, they gave great weight to his age. But they said that there was no allegation, let alone no evidence, there's not even any allegation of threats or the type of intimidation that would come along with an involuntary statement. And so you can't have a statement being involuntary simply because it's custodial. That would render every interview with a juvenile, even when Miranda was applied, even when it was properly followed, inadmissible. And so that can't be the test. But the only evidence that MH has pointed to is the same evidence that he says renders this a custodial interrogation. So we should ask that the court affirm the statement is neither barred by the 5th Amendment Miranda nor by the 14th Amendment in the Due Process Clause.
So, counsel, if the social worker never says, there's nothing in the record, says to either the child or the mother, you are free to go at any time. This is not, you're not mandated to come in here and talk with me. If that is never mentioned to them, does that factor into the totality of the circumstances?
I think, Your Honor, it's a totality test, and so it does factor in, but it is not a strong factor, because what you're talking about, that is essentially an advisement of your Miranda rights in many respects. And so if simply failing to give that type of warning was enough to render a statement involuntary, then there would never be any situation in which case you would be barring these statements in just a basic—
Well, don't you think a social worker should tell that to anybody they're discussing potential criminal activity with?
Your Honor, that may be best practices, and two, that may be a good public policy. Justice Lanzinger, in her concurring opinion in In re MW, talking about statutory rights to counsel, talked about the public policy considerations for when juveniles should have a statutory right as opposed to a constitutional right to counsel. And she emphasized there that it's a policy question that should be left to the General Assembly. So too here. What a social worker must say, or when juvenile statements must be barred when they're made to a social worker, those are public policy questions, but I urge the court not to constitutionalize those and leave them to the General Assembly. If it finds that MH's arguments and those of his amici are persuasive, then it's up to them to adopt that policy. We'd ask the court to affirm the 8th District. Thank you.
Thank you. Counsel, you've got 30 seconds. Turn on your microphone, though, to make use of them.
Couple of things. This was not a friendly conversation between the social worker and the child. I'd want to ask yourself, when a child is talking about these very sensitive topics like his virginity and a single sexual encounter, would he be disclosing that to a total stranger in an authority position? And DJB, while is in fact an agreement that due process applies, DJB informs how due process should be applied. And in that case, they said it's beyond dispute that a juvenile is unlikely to feel free to leave and terminate an interrogation. That informs the voluntariness of any interactions between an interrogator and a juvenile. And it's beyond dispute that the psychological pressure here, the state keeps referring to the lack of coercion, but the psychological vulnerability of children does away with the need for a rubber hose. You don't need a rubber hose. You don't need coercion when you are interrogating a child because of all of the psychological reasons that are laid out in the briefing and in DJB. They are prone to comply with authority figures. They are prone to listening. They're apt to give up their rights because they don't know their rights, even when they're informed of them. So you don't need a rubber hose, as suggested by the government, in order to have a due process violation in interrogating children.
Thank you.
Thank you, Your Honor.
Thank you. We will take the matter under advisement and you'll be notified of our decision. Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.